Under the criminal code, the phrase "with intent to kill" means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires, in order to constitute first-degree intentional homicide, that the defendant acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed, or that the act be brooded over or considered or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill, which is an essential element of this offense, is no more or less than the mental purpose to kill, awareness that the conduct was practically certain to cause the death of another, formed on the instant preceding the act or sometime before that, and which continued to exist at the time of the act. Intent to kill must be found as a fact before you can find the defendant guilty of first-degree intentional homicide. You cannot look into a person's mind to find out his intent. You may determine such intent directly or indirectly from all the facts and evidence concerning this offense. You may consider any statements or conduct of the defendant which indicates his state of mind. You may find intent to kill from such statements or conduct, but you are not required to do so. You are the sole judges of the facts, and you must not find the defendant guilty unless you are satisfied beyond a reasonable doubt that the defendant intended to kill. Proof of motive to commit a crime is not necessary to a conviction. While motive may be shown as a circumstance to aid in establishing the guilt of an the